The magic words beginning the Miranda warning that many know by heart. You have the right to remain silent, may be enshrined in TV shows and films, but this week's Supreme Court decision means its civil rights protections will be significantly reduced. The 6-3 decision in Vega v. Tico essentially concluded that failing to Mirandize or give someone their Miranda warning does not allow a person to sue law enforcement for a federal civil rights violation of the Fifth Amendment's protection against compelled self-incrimination. Back with me is Michael Waldman. So, Michael, what does this decision mean? It is the forgotten decision this week, but I think it's pretty significant. What about you?
It is significant. You're exactly right that this is one of those cherished things that we as Americans take for granted from cop shows, but actually as part of our Constitution. And the majority says, well, yes, this is still the right. You still have the right to remain silent, not to incriminate yourself. And this is supposed to protect against this kind of evidence being used in trials. But if you don't have the ability to enforce that right, if you don't have the ability to bring accountability when your civil rights have been violated, then the right has a lot less force. It's a real clue, too, about the direction of this court. It was another 6-3 opinion. And this was the first year that this supermajority of 6 very conservative doctrinaire justices are all moving in lockstep. This wasn't as big and flashy a case, of course, as Dobbs or the Second Amendment case. But there are a lot of cases like this where bit by bit, this court seems to be wanting to roll back a lot of the advances that many of us took for granted over the last half century.
Yeah, in my reading of this, I walked away thinking, yeah, you have the right to remain silent and to counsel, but you don't have the right to know that. In other words, we don't have to tell you that anymore. So does that mean this decision makes it easier for police to obtain that coerced confession that concerns a lot of folks in police custody?
Well, you know, in theory, you still can't use it at trial, but the police officer who may be coercing doesn't have to worry as much themselves that they're going to be held accountable. And if you don't have accountability, then the right isn't terribly meaningful. You know, we as a society, 2 years after the George Floyd murder, we're still looking for ways to make sure that we can have public safety and accountable policing and fairness. This is not a newfangled thing. This is a basic bedrock protection that's now been chipped away.
Has this given cover to police in that regard? As you mentioned, the officer is not going to be held accountable under federal statute. So how does this incentivize further violations of Miranda moving forward?
You know, again, the idea is that people should not have evidence that was coerced from them used against them at a trial. And for police, that is still a meaningful incentive not to do it, you would think. But it's more meaningful if there's a chance that the individual officers who do something really bad can have civil rights, Section 1983, as it's called, charges filed against them. We have said as a society that when officers of the law, public officials, violate someone's civil rights, part of the way to prevent it, part of the way to bring justice, is to let people go to court and defend themselves and seek redress and seek accountability. When you don't have accountability, the right is not very meaningful.
Why do you think this case, why Miranda? What did the court see in Miranda that they figured, no, we can just set that aside?
You know, part of it, I'm sure, is that they get a lot of these cases and they had a chance to do it because the case was in front of them. But I think it's also the case that you see a pattern where this court knows it has to still mouth the words of recognizing this constitutional right, that constitutional right. But what it seems perfectly comfortable doing is taking away the remedies. Elena Kagan wrote the dissent. She's made this point a number of times relating to other matters, too, that this Supreme Court can mouth the rhetoric of defending constitutional rights, but where it's rather sneaky in its follow-through is in taking away the remedies.
Michael Waldman, thank you very, very much. Appreciate it. Folks, we've still got a ton to cover in the second hour of AYMAN. Coming up, Jim Obergefell, the lead plaintiff in the case that made same-sex marriage legal, responds to Clarence Thomas's argument that other rights should be reconsidered now that Roe has been overturned. Plus, give me a break. Moderate senators are claiming they were duped by conservative justices on Roe. But who are these senators fooling? Then we're going to give a shout out to the one man who single-handedly made the January 6 hearings worthwhile, Kevin McCarthy. We'll just leave it there. I'm Michael Steele in for Ayman Mohyeldin. Let's get started.